Let's work our way through the fact patterns from the July 2023 California Bar Exam. Beginning with the essays, this is Essay 1. As always, the first thing we do is read the call of the question and try to figure out what the subject is so that we can have a really clear, clean, brief organization of the law in mind while we read the fact pattern. This call says which of these defendants might reasonably be found liable for damages arising from a car accident. So when I see there are defendants already, I look to the sentence above that to see what the lawsuit is about. It's a liability for damages, so it's a civil suit, and it says Priya, plaintiff name is always a P name on the California Bar, sued Amy, ABC, Bob, Carl, and Sam for damages. ABC looks like an entity. A, Amy, B, Bob, C, Carl. And then we have a fourth person, Sam. If you look at that call and you've worked enough fact patterns in the past, you know that this has to be a business entity, most likely a partnership. A, B, and C look like principals in this business, probably partners. But then we have a fourth person, Sam. And the big factual issue here is going to be whether Sam is also considered part of the business enterprise for liability purposes. So I think we have a partnership fact pattern. Let's go to the facts to make sure we're right. It says Amy, Bob, and Carl are partners in the ABC law firm, which operates under a general partnership. There you go. It really is a partnership fact pattern. And as I read the facts, I need to have my understanding of the structure of partnership law in mind. So let's go and look at my structure for partnership, knowing that the California Bar sometimes tests winding up, who gets what when outside creditors come and need to be paid off. But this looks more like an issue of who is personally liable, and is the partnership itself liable for whatever caused this accident. To understand all of that, we need to look at partnership law and know what needs to be in your mind as you read through the facts so that the issues come out and you can line up the facts as you read the hypothetical. So I'm going over to Proponix, which is a software platform we developed to hold our organization of the law, and so that we can open it, unfold it, fold it back up, use it to study whether our memorization is accurate. I go to partnership law and I see the main topics in partnership: applicable law, formation and effects, and so on. And of course, the more general principles are in applicable law. One that's important for our purposes is the agency principle that says each partner is the principal and agent of each other. Each is a fiduciary of the other. But go back to formation and effect in partnership, which I think is where most of my facts are going to be in this hypothetical, because we want to know if this partnership includes Sam. And so to know that, to determine that, we need to know how you form a partnership. You need contract capacity, you need intent, and you need a purpose. The intent can be expressed. It can be a written partnership agreement, but it doesn't have to be. It can be implied based on conduct. And that's where I expect to find most of the facts that go to Sam. The facts to show intent include profit sharing, agreement to share losses, and other kinds of conduct and facts. Profit sharing is prima facie evidence of a partnership, but notice here that profit sharing, if it's for discharge of debt, is not evidence of a partnership. So if they give us profit sharing, we have to decide whether it's pure profit sharing or whether it really is discharge of a debt. I'm looking for facts that go to whether there's the intent that this plaintiff can demonstrate for Sam to be a part of the partnership. And I expect to find, probably a good dense paragraph of facts that go to this area of partnership law. So this goes to the intent implied. But there's another way someone can be part of a partnership for legal purposes, and that's by estoppel. If someone holds himself out, acts or represents as a partner to third parties, then that person will be liable as a partner and is estopped from denying it. And there are elements to that as well. I haven't seen the facts yet, so I don't know what they are about Sam, but all of this structure of the law is in my mind when I start reading further in the fact pattern. And why do we care about whether Sam is a member of the partnership or not? I don't even know yet whether Sam is the one who was in the accident with Priya or whether it's one of the partners, A, B, or C. But go down to formation and effect. Look at the effect of forming a partnership. It results in joint and several unlimited personal liability for the partners. We have a lot of detail in this part of the schema. I don't see anything in that call that would ask us to analyze sharing profits and losses or property acquired by a partnership, but the issue of joint and several liability is at the heart of what they're asking us in the call of the question. And that call is asking us about obligations to a third party. So look at rights and obligations, liability to third parties. And let's see what detail we have under there, because this is also really relevant to the call. Under partnership liability, we see that the partnership is liable for all acts committed within the scope of the partnership and for acts committed with authority. We also see that individual partners have joint and several personal liability, but creditors can't proceed against personal assets of individual partners until the remedies against the partnership are exhausted. And there are exceptions to that. But this is basically the law that I think we're going to need to answer this call. Look at authority. Apparent authority. An act by a partner binds the partnership if the act is within the scope of the partnership. There's also actual authority, authority expressly granted within the partnership agreement. I don't think we have issues of dissociation or termination, winding up, dissolution. So I think the law we need is what we've already taken a quick look at here. So let's go back to the hypothetical. So the first sentence told us that A, B, and C were partners and that they had a partnership agreement. It goes on to say that ABC provides all firm attorneys with cell phones to facilitate prompt attorney-client communications. ABC has a policy that all firm attorneys must carry their work-provided cell phones with them at all times, and that all client emails must be responded to immediately, at least with a personal acknowledgement of receipt. What do those facts go to? Somehow that cell phone policy has to be at the heart of what caused this accident. So I'm expecting to see that coming up. We see Sam, an attorney well known for his many highly publicized trials, often works closely with ABC but is not a party to the written ABC partnership agreement. But we know from the law we've already seen that you don't have to have a written agreement. There are other ways to be found to be part of a partnership. ABC believes that Sam's presence raises the profile and prestige of ABC. Okay, that's the basic facts about Sam. And so a lot of my analysis is going to go to whether Sam is effectively a partner in this partnership. Because if he is, then the partnership would be liable for his actions in the course and scope, and he would be personally liable for any partnership liability. So we see Sam leases an office in the suite of offices used by ABC, for which ABC charges Sam $3,000 per month. Okay, that doesn't make Sam a partner. So if you think back to that law we covered, leasing an office from a partnership does not make one a partner. The ABC receptionist greets all clients of ABC and Sam. Now that fact is a little more ambiguous. Sam uses the ABC firm name and telephone number on his letterhead. So he is holding himself out to be part of the partnership. That's an important fact. That drives us closer to being able to call Sam a partner. Then we see Sam bills his clients directly for his services. That fact argues more that he's not a partner, right? Sam also receives 10% of the annual profits of ABC in recognition of his value to the firm. That's a crucial fact, because profit sharing is prima facie evidence of a partnership. So look at the structure of what this hypothetical did, the law professor who wrote this hypothetical. In the first paragraph, they gave us a partnership, and with the intent express for Amy, Bob, and Carl, but not for Sam. In the second paragraph, they gave us Sam, and they gave us basic facts about Sam, and then went on in the third paragraph to give us all kinds of detailed facts that let us argue whether Sam is actually impliedly intended to be part of this partnership. The crucial fact being the profit sharing because of his value to the firm. And that is prima facie evidence of a partnership agreement with Sam. You can use all of the facts in this paragraph to show what implies intent and what does not, and then come to your conclusion. The other thing you can use the facts in this paragraph for is to analyze whether by estoppel Sam is part of this partnership. Did ABC hold him out? Did he hold himself out as being a member of the partnership? We don't know yet what's going to happen further on, but I would put that analysis in here as well to show the greater that I know about estoppel in partnership formation. But we still haven't seen the accident. So next we have, after work one day, Amy was driving in heavy traffic to attend a baseball game when she received an urgent email from an ABC client. Okay, so she's on her personal time, but she's got that work cell phone, and remember the policy in the first paragraph. She is required, as part of the partnership agreement, to respond to that email. So now what happens? While briefly stopped in traffic, Amy attempted to answer the email on her work-provided cell phone. Now, these facts go to whether Amy's actions were within the scope of the partnership business. In other words, is the partnership going to be liable for what happens? Due to the distraction, Amy negligently caused a car accident that was the actual and proximate cause of serious injuries to the other driver, Priya. Okay, so Sam didn't cause the accident. Amy did, and Amy did because she was performing a partnership required task. So the basic rule about liability for tort is that you're responsible for your own actions. So Amy is personally responsible for that accident. There's no way around that. She bears personal liability. But do her partners in the partnership? That's where the analysis about this being within the course and scope of the partnership business comes in. Because once you analyze that and find that she was acting within the course and scope of the partnership, now you have the partnership liable as well. And the very nature of a general partnership is that all of the partners bear joint and several personal liability. But get the rest of that law into your answer, into your book, that when we're talking about liability to a third party, that the partners have joint and several personal liability for torts, but creditors cannot proceed against the personal assets of individual partners until remedies against the partnership are exhausted. You want the rest of that in your answer as well to deepen your score with that grader. Notice how cleanly and well laid out this hypothetical is, and most of the California bar hypotheticals are. The first paragraph sets up the basic problem and basic facts like the fact that there was an express partnership agreement here. The second paragraph goes on to give you more detail about something. Here it's about Sam, the outside member, at least not part of the written partnership agreement. The third paragraph gives you pretty intense facts that you can use to decide whether Sam is actually impliedly intended to be a member of this partnership, whether the partnership or he himself is holding himself out to be part of the partnership so that a third party might rely on that fact. The fourth paragraph gives you what led to the cause of action here and also provides more information. But generally, California bar hypotheticals are very logically ordered, and they tend to go, if there are multiple calls, the paragraphs tend to flow such that the first paragraph goes to the first call, the second paragraph to the second call. This one has only one call, but nonetheless, look at how orderly it is. Recall how little law there was in the schema, in our organization of a law that I went through with you. And using just that and understanding it, you can answer this hypothetical well enough to get yourself a pretty high score on a bar exam. I don't know who my audience is for this video. I don't know who's watching this video. If you're a bar candidate, then you should have worked a whole lot of essays already. If you're a law student learning the law, then perhaps you haven't worked as many law essays. If you would do me the kindness, tell me where you stand. What would help you? Would it help you if we built our Patreon channel so that we took this hypothetical and others that we've debriefed, and we literally took these facts and showed you how we would turn them into an actual written answer? Would it help you to have more hypotheticals debriefed than we have on this channel? Give me some feedback in the comments about what would help the most. And if you've made it this far, think about this one and give me some feedback in the comments. I've, for a lot of years now, had a daydream about providing enough content to help people prepare for the bar at very, very low cost. And it seems to me that could be done with a Patreon channel, with more content like this, with more technique sort of videos and then put out content for $30, $50 a month. Is that something that you think is feasible and that you would value? Let me know, please, in the comments.